We've got an interactive session for you today. For those of you that don't know who I am, I'm Sean Cottrell. I'm the CEO and founder of LawInSport. I'm going to be your moderator for today, but thankfully you're not going to have to hear too much from me. So this webinar is a follow-on webinar. We held one last Friday in which we discussed the impact of COVID-19 on football players' contracts, but that was from a more international perspective. Following that, we ran out of time to answer about 30 questions or so during that webinar, and then we received a bunch of questions come through over email and in our forum. Therefore, speaking to John Mehrzad, who many of you will know, and I'll introduce QC, who I'll introduce you to in a minute, we decided that it was a great idea to have a specific UK-based webinar to address some of your issues. So if you're not familiar with the format is quite a simple one. We're going to have some presentations, around 5 to 8 minutes each. We're going to keep it nice and short, quite tight, so we can have as much time as possible for Q&A, as that's where we ran out of time last week. If you're not familiar with the platform, if you want to ask a question, you can either raise your hand. So there's a sign like a hand. Don't just sit there raising your hands in your room on your own, because I won't be able to see it. But in the system, if you were to raise your hand on the software, then that notifies us there's a question. You can also type a question for those of you that don't want to use a microphone, or you've already got questions that you've already thought of and they want specific answers to. Please put those in at the appropriate moment in time. I will come to the specific speaker. If there's someone you want it to be directed to, please let us know. If not, I'll ask it to the whole panel. So we're scheduled for roughly around sort of 30 minutes or thereabouts of presentations, and then we'll move on to Q&A. I said if there's a burning question that's very relevant to a particular speaker at a particular moment in time, I will interject, and I'll try and keep us running on time. The other thing is I'm probably one of the fastest talkers in sports law, so apologies if you're struggling to keep up, but this is a UK specific webinar, so hopefully I'll be forgiven and it'll be easy for you to comprehend. Now, so to introduce our speakers in the order of which they'll be speaking, we have David Winnie. David is a senior solicitor at Charles Douglas Solicitors in Mayfair, where he heads up their sports law team. He's represented clients before the Player Related Disputes Commission, League Appeals Committee, FA Rule K arbitrations. He's also brought matters before the FIFA Dispute Resolution Chamber and the Court of Arbitration for Sport. Very relevant for today. Before David became a solicitor, he was a professional football player for nearly 20 years, where he represented Scotland in under-21 level and played in UEFA Cup, Champions League and European Cup Winners' Cup matches. David is also an FA registered intermediary and has recently established an international sports agency handling elite sportsmen and women. Thank you, David, for joining. Next up, many of you will know Paul Gilroy QC, who is a leading sport and employment lawyer. He is an arbitrator and mediator, and he sits in a judicial capacity for the FA and is a member of a range of thematic arbitration panels for Sports Resolution UK, ranging from athlete selection and eligibility to integrity and disciplinary matters. He is also an advocate, and he holds a record number of appearances before the Premier League Managers Arbitration Tribunal. He is also a part-time employment job of over 20 years standing, which is also relevant. Although I know, Paul, you were trying to underplay that for today's webinar. I think your perspective is absolutely vital, and I think that lends itself very well to some of the questions we've already received. So thank you, Paul, for joining. Next up, many of you who tuned in last week, and I know there's a bunch of you who tuned in last week. We have John Mehrzad QC, who's the head of sport group at Littleton Chambers. He was appointed QC after nearly 13 years in practice. He specialises in sports law with a particular focus on employment and commercial disputes. He sits also as a sports arbitrator and panellist in the UK and abroad, including for the FA, the English Football League, the Court of Arbitration for Sport and Sport Resolution. He's also preeminent in terms of carrying out independent sporting reviews. John, thanks for joining. Next up, we have Bianca Balmelli, who is an advocate in South Africa. Before qualifying as a barrister in England and Wales, she's a member of Littleton Sports Law Group, specialising in commercial, arbitral and employment-related disputes. Bianca, thank you for joining. So, to kick us off, to use the footballing pun, too many days. This is the problem, right? Too many days spent indoors. This is what happens to you. So, first up, we have David. And now, David, if you could just talk about, from your experience, what's over the last few weeks, what some of the questions that you've had, and then we'll take your presentation. I think come on to then come on to Paul, John, and Bianca. And as I said, I'll be fielding questions as then when they come in through the chat, the online system. Thank you. Over to you, David.
Yep, thanks very much. Today I'm going to speak about furlough or furloughing. I mean, we've all heard that term now, how it relates within the coronavirus job retention scheme, and how that relates to football clubs, football players, and any issues arising from it. On the 20th of March, the government announced the coronavirus job retention scheme, and the initial government guidance provided a brief overview of it, and more detailed guidance was released on the 26th of March, I believe, in this last month. Essentially, the scheme is a grant. It's a promise by the government to repay employers who don't dismiss employees. It's not set out in legislation, and it operates through the PAYE scheme. As an employer, you can only claim for furloughed employees that were on your payroll or PAYE payroll on or before 20th of February 2020. And payment is made via the scheme if and to the extent that qualifying factors are met. In a legal context, it doesn't change employment law. It doesn't give employers a right to place an employee in furlough or a right to reduce their wages to 80%, which I'll come on to. Both contractual and statutory protections exist, and a furlough can't be imposed by an employer on an employee. As I said, the scheme doesn't change existing statutory rights. For example, the right not to be dismissed fairly, the right to redundancy payment, protection from discrimination or paid annual leave, nor does it change common law rights. The scheme involves the furloughing, if that's the right term, of employees, placing them on leave of absence, effectively. As such, employees will remain on a payroll, but they're not allowed to work whilst being furloughed. That, which I'll come on to, is a specific point, a specific issue with regards to clubs and particular players. As part of the new guidance issued on the 26th of March, the government confirmed that, and I'll read this here. Employers can use a portal to claim 80% of furloughed employees' usual monthly wage costs, up to £2,500 a month, plus the associated employer NI contributions and minimum automatic enrolment employer pension contributions on that wage. As part of the new guidance as well, the government clarified that for full and part-time staff, employees' actual salary before tax and as of the 20th of February 2020 should be used to calculate the 80%. This excludes fees, commission and bonuses, which that's relevant in a football context. Government also confirmed we backdated to the 1st of March 2020, and it will be open for at least 3 months. But I mean, given the current situation, that may be extended, and employers can use the scheme any time during this period. That said, how does this relate to players? How does it relate to clubs? In terms of specific elements of this scheme to football, I think given the financial thresholds of the scheme, I don't think it's suitable for Premier League players. I don't even think it's maybe for Championship. It's maybe lower down the pyramid. As such, it may provide more of a financial relief to lower league football clubs with a smaller wage bill per employee, sample compared to a deferral of a percentage or a pay cut. Secondly, as per the government guidance, football clubs should look to get the agreement of all the players that they wish to place on furlough. As I mentioned, that the scheme remains subject to existing employment law obligations, and therefore, if the players don't agree to being placed on furlough, then there could be a risk here of, for example, unlawful deduction from wages, or a player's resign, which probably wouldn't happen anyway in practical terms, or a constructive dismissal claim, a breach of contract, something along those lines. In addition, for players, football players on standard fixed term contracts, which football players are, unless there's a specific provision in the contract which would enable the club to end the contract early, then the club can't purport to end the contract, but for example, by way of redundancy or otherwise. And therefore, the employee is entitled to full payment under the terms of the contract unless compromise is agreed. Thirdly, I've noticed that the scheme provides or will provide a system of reimbursement up to the relevant threshold, which again I'll come on to. As such, my view on it is that I think clubs will have to continue to pay their employees, the players, unless they obtain a consent to a wage deferral and then reclaim the money later on. If clubs do decide to top up wages for employees, which they're entitled to do so, government guidance is clear that it won't refund employers, it won't refund clubs for this sum, together with any related NI contributions. So such additional costs will fall on the football clubs. The key point here, I think it needs to stress, is that it needs to be by agreement, employee written agreement through the players. The clubs cannot unilaterally impose this on the players. A player that you place on furlough must be furloughed for a minimum of 3 consecutive weeks. When they return to work, they need to be taken off furlough, and this is an issue again, which we'll come on to in a bit. Employees, they can be furloughed multiple times, but each separate instance must be for a minimum of 3 consecutive weeks. In a football context, and in respect of being furloughed, the individual, the employee, cannot work during this period. How does that relate to football players here? And it's a crucial factor, I think. For example, the present HMRC's published guidance in this, and I'll read it again, on the scheme provides that undertaking work includes providing services or generating revenue, but that employees are able to undertake training as long as it does not provide services to or generate revenue for or on behalf of your organisation. There's an argument here, I think, that a football player taking part in physical training activities should be seen as undertaking training, since it provides a kind of baseline level of fitness for players to undertake their playing services for which they're paid anyway once the lockdown is over. On the flip side of that, however, physical fitness activities training, it does form a part of the day-to-day activities of a player in normal circumstances. It's intrinsic to their job. It's not an add-on. And can be said to be part of the playing services that the player provides to the club, or at the very least linked to them anyway.
Sorry, David. Just to bring
Sure.
John in here briefly, if it's okay. If I'm right, it's basically this was something that John, you alluded to and discussed last week, which was the difficulty around the services which a player provides, and that this could be particularly complex given that a lot of players generate revenue for both their club and or at least profile indirectly or directly by doing various videos, and that seems to be on various platforms. David and John in particular, how do you see that being problematic in this case, particularly for those, as you were saying, for those let's say lower down the pyramid?
I think players, the way my view on it anyway is that players can go out and train, do their own thing to keep fit. However, when it comes to the stage where their employer, the club, is providing formal instruction, a training program, something like that, then I think it would be deemed it would take them out of this. They wouldn't be eligible for the scheme. And I think well, I mean, frankly, the position is not clear cut.
Right.
But I do think if they take formal instruction, then they're taking it out of the scheme.
Okay, sorry, I apologise. I should have said this at the beginning. I apologise to the speakers in advance. I'm going to be quite brutal with timekeeping and interjection just to keep things moving quickly, because I think there's a lot to get through in a short period of time. So, John, did you have anything you wanted to add to that?
Yeah, hopefully you can all hear me. It's one of the great benefits of this kind of forum is that this has been a subject of debate over the last week, because the government guidance, when it first came out, suggested that training was fine for employees to continue to do, but the key part of that guidance is that that training cannot be for financial benefit. And part of, as David has said, players' contracts is that they must keep fit at all times. And so the question is where the dividing line is. And I think David's really hit the nail on the head, that if you are following a club-orientated instruction training plan, even if you are being put out and given some sprints to do by Jose Mourinho in a park in North London, that is under the instruction of the club, and that is in line with the obligations under your contract for which you are being paid. And I can see that falling foul of the furloughing scheme, whereas conversely, doing a few press-ups at home, or even sending them out on YouTube, as some players have done, I don't think amounts to training for financial benefit. That's just staying fit and doing some exercises the government would suggest.
Right. Okay. I think I think that we can maybe pick this up then in the Q&A afterwards, because I think I haven't received particular questions yet, so hopefully people are happy to either speak on this particular issue later on. But I know there's differing opinions from some of the people who are listening at the moment, which I think again is, I think the benefit of this forum and this discussion is that we can help people try to come to the best possible outcome, right, of all of this. This is the intention of this webinar, the intention of all the stuff that we're doing, and I'm sure many others. So, David, did you have anything briefly, because you've run out of time, partly because I interjected, but did you have anything briefly, so sorry, that you wanted to add?
No, I just think further down the line with following with players, when and if the season resumes, I think there could be possible issues for clubs coming back to training. I mean, I've spoken about this before. They're going to go straight into the business end of the season again. So them training will take them out of the furlough, take them out of the scheme. Sorry. So clubs, they need to be aware of that. You know, that issue.
As if there's not enough administration to worry about at the moment. I feel for everyone at this time. Brilliant, thanks, David. Paul, now over to you. Now, I believe you're going to pick up on some issues around various contractual options that are available and maybe used. So, Paul, I'll hand over to you.
Yes, again, just making sure I have audio. Can you hear me okay?
Yeah, we can hear you fine. Thank you. Your lovely
Excellent.
voice.
Yeah. Well, David's been talking to you about furloughs and what's really in front of us all right at the moment. That's the immediate position that we're all facing. I'm going to talk briefly about the medium term and the long term, because there is a reckoning coming here from an employment law point of view. Anything I say in the course of my presentation is not based on any inside first-hand information. I've researched this from various sources that are available to all of us. So I'm not disclosing anything from the inside. And I'm conscious, for example, we have a number of people on this webinar who will be from certain organizations who will have first-hand information. So I'm deliberately quoting from publicly available sources. But what is publicly known is that there is going to be a tsunami of employment litigation that follows this unprecedented crisis that we are facing. Because at the moment, everyone is in lockdown, everyone is contemplating the seriousness of this situation. But when the dust eventually settles, please God that it does, people are going to be examining and picking over the bones of what happened, and they're going to be standing on their rights and entitlements. And even if there is only a small percentage of people who seek to litigate on that front, that's still going to be substantial. It is estimated that currently there are 2 million people facing job losses in the country, and if you play the numbers game, you simply apply a percentage, even a fraction, a tiny fraction of those leading to litigation, we're going to have an avalanche of cases coming forward. Second point is that when the courts, tribunals, arbitration panels are adjudicating on these issues, they are facing pretty unique circumstances, but lawyers have to be very careful to suggest that this provides carte blanche to normal contractual principles, statutory principles in the employment field applying. And so the context here is, here's some facts that we're dealing with. Premier League football clubs, unlikely they will go to the wall in the short term, certainly in the short term. But the phrase that I've seen used, and I think it's very apposite, is that of an egg timer that has been turned over. And the problem that we're all worried about is that no one knows when the matches are going to restart, so the egg timer can be turned back again before the sand has run out. Because if that sand does run out, that is going to send people into administration, into liquidation. For some years now, Deloitte have recommended as a model of choice that clubs should operate on the basis of a wages to turnover ratio of 60%, and lots of clubs have managed to achieve that. In the Premier League, it's generally observed there are clubs in the Championship with a worrying 111%. And if you apply the Mr. McCorber principles, running on that basis can only lead to one conclusion. And I think that the factual event that is going to cause even the top clubs, or especially the top clubs, to confront these issues is when we get the time in the summer when the TV money normally arrives, that is relied upon so much by the top clubs, that is when the grim realization is going to dawn about the predicament that the clubs are facing. I'll give you one brief fact to demonstrate the path that we're on. In 2016-17 season, 17 of the top 20 clubs, the Premier League clubs, were in the black. Last season, before any of these difficulties, that figure dropped to 7. So if it's 7 pre-COVID-19, it doesn't take a genius to work out what we're heading for. There are some Premier League clubs that have wage to turnover ratios of more than 80%.
Paul, I'm sorry to interrupt you. You haven't got too long left, but you've got enough time, I think, to cover some further points and clarify some certain points. So, okay, like most other sectors, then the financial pressures that are inflicting themselves on football at this moment in time are very real. What are the options that people are looking at, and what can you really do? Yeah.
In the post-furlough period, and I know that companies in the general business sphere are looking at this, is restructuring and redundancy, probably the other way around sometimes. Redundancy involves one-to-one consultation with affected staff. Depending on the numbers, it involves collective consultation. If you fail to observe those tests on the one-to-one level, you will have an unfair dismissal claim. And on the collective level, if there are more than 20 people that you are contemplating making redundant in less than 90 days, you can be stung with what is called a protective award, which is an award that is meant to penalise. It's unusual in English law. It's meant to penalise employers for failing to engage with their collective consultation obligations. Clubs would be very wise in the very quick short term to think about redundancy, to think about reorganization, to think about collective redundancy obligations, because they have to notify the redundancy payment service if they're going to do collective consultation. Some people on the call will know about the HR1 process, and on a one-to-one level, consideration has to be given to selection criteria and the like, and consultation with employees, selection process taking place, appeals against selection, and the like, if the employer wants to survive the process. Now, I think on my topics also, I had to touch upon, I will give a couple of sentences because I'm being given the 54321 on this, is the new insolvency rules. We now have a hiatus in the area of insolvency law. There has been a 3-month suspension of the wrongful trading rules, effective back to the 1st of March. That means that directors will not be personally liable, certainly in this 3-month period, to pay personal compensation if the company goes into insolvent liquidation, and sometime before that the director knew or ought to have known there was no reasonable prospect of the debts being met. It's also a criminal offence, wrongful trading. We also have moratorium, an interim moratorium being introduced up to 90 days that will give companies facing liquidity issues the time and what's been referred to as the breathing space to seek a rescue package or to restructure and prevent creditors from enforcing debts during that period. And that's been put forward by the government on the basis of the phrase, hopefully weathering the storm that the economy is presently facing.
So to summarise this then, so essentially the usual redundancy rules apply, which I'm guessing then can be quite time consuming to do properly, given the criteria. Is that correct?
Yes, the collective redundancy timescales are very prescribed. So if you've got 20 or more, then you have to complete the HR1 process at least 30 or 45 days in advance of the first dismissal taking effect. If it's one-to-one, there's no statutory timescale, but a tribunal will expect to see consultation in good time. Now, the key, I think, on the collective consultation is going to be there is a defence to these claims of special circumstances. Now, people who've tread the boards for many years in the tribunals will know that tribunals are very slow to accept financial meltdown as amounting to special circumstances, because these matters are very heavily scrutinised when you get to a contested tribunal hearing. Having said that, in my entire career, I have never seen a set of factual circumstances that seems more prone to the potential for the special circumstances defence succeeding, subject to employers, football clubs following proper rules and proper principles and proper consultation in their processes.
Okay, thank you, Paul. That's very helpful. And I know we've already got a whole bunch of questions, so thank you for those who have already written and submitted some questions. I know we've got a couple of people who are waiting patiently with their hands up, and we'll come to you first, and then we'll go to the written questions after that. I'm checking if there's anything burning that is urgent. Please do write the message and put urgent on it if it's something that's pertinent for that point. If it can wait, 20 minutes or 15 minutes now for the if I could do my maths, it'd be 16, but the if you can wait that long, then we'll come to you. Right now, John, over to you. Now, this is quite FIFA have obviously just made some announcements over the last 2 days, so I think you're going to cover that, but I'll hand over to you. I've got to need, if I unmute your mic. Now I'm muting your mic. Over to you.
Thanks a lot, Sean. Some of you who tuned in last week will know that there was a discussion at a high level about the extension to the current football season. It is a truism that a week is a long time in politics. It is also fair to say that a week is a very long time in football. Some would say that there may be one and the same. Let me start off by discussing the FIFA guidance, which came out 2 days ago. And it is an interesting set of recommendations and proposals which fairly recognise that it has no binding force, because, of course, there are 211 different member organisations of FIFA, all of which have their own national employment laws which govern their specific player contracts. But the reason why it's very interesting to start off with that guidance is to see where the global regulator wants the direction of travel to go. And I'm going to spend a little bit of time just discussing their proposals. I will also discuss some of the factors that they say should be taken into account in terms of dispute resolution at FIFA level, because I think that's going to be quite informative for listeners. And then I'm going to go back to player stroke agents' interests within the UK and finish off with clubs' interests. So let's start off with those FIFA recommendations. 2 days ago, 7th of April, they effectively came forward with 2 proposals in response to the coronavirus outbreak. Number one, that contracts, it is proposed and recommended that they should be extended until the end of a renewed season. And secondly, that the transfer windows should be delayed until the end of a renewed season. Let's just start off with the basis, the foundation upon which they make both proposals. First of all, it is asserted that the whole purpose and intention behind player contracts is that they run until the end of the season. Therefore, it is asserted that the intention of the parties to a player contract, the club and the player, was very much that that contract should run until the end of whenever that the playing season ends. They also further add weight to that suggestion that in order to preserve sporting integrity and stability, that should be the case. Now, of course, they recognise, though, that those contracts are between separate parties, between clubs and players. And that is why it's merely a recommendation that those clubs and players and any representative bodies, if there are collective agreements, follow that particular guidance. So you can see they want to have collaboration, they want agreement, they want seasons to finish. And there are all kinds of stability reasons, financial reasons why that's the case. But what I found quite interesting is, of course, they also set out 5 points, this is FIFA, in terms of situations where agreements are not reached between clubs and players, and those disputes end up before FIFA bodies. Now, this may be of interest, probably more so for people who are not within jurisdiction, because there are specific arbitral bodies that will deal with it here, which I'll come on to in a moment. But I think it's worth just thinking about these 5 factors. 1, whether there is a genuine attempt by the club to reach agreement by the players. So as Paul said a moment ago, form of consultation with the players in order to try and reach agreement. And number 2, the economic status of the club. If a club effectively has got no money to pay an extended contract, which is going to be relevant for clubs lower down the league, as Paul and David have both mentioned, that's going to be a relevant factor. Thirdly, the proportionality of any adjustments to the player contract. So if what's being suggested is a mere 10 or 20% deferral to salary, i.e. you'll be paid later, as opposed to a 50% straight pay cut, then you can see how the level of any reduction could come into play. Fourthly, the net income proposal of the player after that adjustment is made. So you also then take into account any tax deductions, which are going to be relevant for different jurisdictions. And then lastly, whether the player was treated equally or not. Obviously, if you're singling out one particular player and asking them to take a much bigger pay cut than their maybe higher paid club colleagues, then you could see how that's not fair. And of course, what this all goes to is whether there is just cause to terminate a contract in the first place. And that has repercussions in terms of being able to walk out of a contract and become effectively a free agent and get compensation and sporting sanctions. So that's FIFA. Let me now, in the last 2 or 3 minutes, try and move on to the UK and see how those work or don't work in the UK. So let's start with players and agents. There are standard form player contracts, as many listeners will know, in terms of the Premier League and the EFL. The standard form contract means that those contracts end on the 30th of June. The suggestion, in my respectful view, because I do have respect for FIFA, these are challenging times, not easy to come to bring together guidance. They've had to liaise with various stakeholders, but the suggestion that a set date, in fact, means on the expiry of a specific event, i.e. the end of a season. And that was the intention of the parties when they entered into that contract. In my view, from an English and Wales law perspective, is a non-starter. I think it's also important to put in context how many players we're talking about who are going to have their contracts expire on the 30th of June, and I include loan players here. And the statistics I've seen, it's about 13% of Premier League players, and I suspect somewhat higher in the lower divisions because they tend to be on slightly shorter term contracts. And so you're potentially looking at hundreds of players who are going to have to be negotiated with in order to give contractual extensions, them and their agents. There are no variation clauses in standard form contracts which can be used by clubs. A unilateral change to contracts, as has been mentioned by Paul and David, cannot be imposed. That would be a constructive unfair dismissal, would be a breach of contract. Players could walk out of their contracts and seek the remainder of their fixed term and compensation. So ultimately, an agreement has to be arrived at. But that's an agreement in terms of future wages to an indeterminate stage in the future. And also, let's not forget, agents who are paid on a renewal or an extension of a player contract. And it's typically the clubs that pay. So let me now move on to clubs. And ultimately, this is about cost. And I think it's fair, Paul's analysis in terms of the amount of money in the game, that some Premier League clubs will be able to pay these sums, but most EFL clubs who have not budgeted for extended seasons for another few months will have to pay not simply an increased amount towards the players, but potentially commissions as well. That's the cost size. Then there's a regulatory size, which is squad sizes being limited to 25. If players are coming back effectively to clubs who've been on loan, there may not be space for them. And so the reality is that I think that there are, in fact, two options that are available. One is that there's agreement at a cost, and that cost may well send clubs under unless there's a form of bailout. Alternatively, players simply decide to sit out part of the extended season, looking for then to be free agents in the future, good signing on fees, increased wages. But of course, that then calls into question the entire key point about sporting integrity. Is it really the same season that happened before the virus incurred? Because certain clubs would have played against different squads compared to ones in the future. And it then not only is a financial question, but as a sporting integrity question. So hopefully that's about an 8-9 minute summary of the developments of last week. There you go. I like to be bang on the money, as it were.
But so, John, I was just going to say, but within this, you know, we're dealing with what's going on right now. As always, as we've seen, is that there's the ability to be flexible to make amendments to sort of cope with this. And you know, do you envisage that? Oh, I like to think that, you know, whether you're an agent, whether you're a player, there's going to, you know, if your club or the organisation or the league is not in existence because it goes into administration or liquidation, at the end of all this, you lose anyway, right? So there'll be some, you'd like to think there'll be some pragmatism about, you know, how people, how much ground people give up, or how many rights they give up, or how much remuneration they're going to give up over this period. Would that be correct? Or does that, do you think that puts people in a weakened position to take that sort of more pragmatic approach?
Well, look, you know, it's a kind of cliche to say a negotiated compromise, which may not be ideal for any party, is better than the type of situation where the repercussions of liquidation or sporting integrity are challenged. But let's be realistic. There have been discussions between various stakeholders domestically for some time already, and there have not been agreements on, for example, player cuts yet. Clubs are doing things in very different ways. You know, I'm not going to breach confidentiality, but just for example, some clubs. No, but I mean, some clubs and some professional clubs in professional sports are furloughing players and think that they can do so. Others are not doing that. Some are promising deferrals. Others are asking for a straight agreement for wage cuts. And where there's so many different options, it's very difficult to reach a collective position, certainly at an association level. And time is going to run out because, of course, you know, these seasons have to end at some point, and we've got to get them up and running again. Otherwise, it's simply not going to be practical. I know David later on in Q&A will be talking about a lead-in time in terms of duties of care and health and safety. So I'm afraid, you know, this can't be an ongoing negotiation.
Okay, so basically, like in all areas, including government,
just hot off the press.
Yep, go for it, Paul.
Hot off the press, Sean. A point that John made about no one's announced anything. I think today, again, this is not first-hand information; it's public knowledge. Southampton have become the first Premier League team to announce wage deferral today.
Yes.
Right. Okay.
But it's all going to be piecemeal, and everyone's going to be doing their own thing.
Yeah. Okay. Yeah. Brilliant. Thanks for that, Paul. Now, Bianca, over to you. I'm going to mute your mic, John, and mute my mic. You're going to be looking at, if I'm right now, what the impact of event cancellation is going to be in terms of more broadly, in terms of the clauses that are there and how that impacts player contracts. I'm going to hand over to you right now. Hopefully the mic's working. Have I not unmuted you? No, sorry, I got you on twice there. Try now.
I think you can hear me now.
Perfect.
So with regards to events, like we've been discussing, some events, I mean, the Premier League season's been postponed, well, not postponed, shifted out. On the other hand, UEFA have said that if they can't play the Champions League final by the 3rd of August, it'll be cancelled. So there are important aspects that will have to be dealt with, and it'll be important as to obviously whether the event is cancelled or merely delayed. Now, ordinarily, all sport is underlined by various contractual obligations and relationships, and those will then be impacted by these events and these delays. So the three main concepts in that regard would be force majeure clauses, material adverse change clauses, and frustration. Now, in a more broader sense, parties would need to look whether or not their contracts contained force majeure clauses and material adverse change clauses. However, the standard form Premier League and EFL player contracts don't contain these types of clauses, so that's not an issue. I know people keep hearing force majeure and are thinking, oh, this is going to be applicable. However, the problem is force majeure is actually a civil law concept, so it comes from the continent, whereas in English law, it's not actually a doctrine in English law, rather it's a principle that comes into play when parties actually agree to it. Now, as I've said, the standard form contracts don't contain these clauses, and therefore player contracts won't be affected by it. But it's still useful, as I'm sure some listeners here will be representing other parties, where it's important for more commercial contracts, because it's likely that they will contain these types of clauses. And in that regard, it's important to remember that even though it's now big news at the moment, in essence, it is just a contractual term, and parties will need to clearly read their contracts and assess on ordinary interpretation principles what the obligations and what flows from the various aspects. Just to clarify, a force majeure clause basically allows parties to not perform if a certain event occurs which is beyond the control of the parties. Now, I briefly just mentioned a Mact clause. Once again, this is not something that will affect the players. This is more something to be found in mergers and acquisition documents, finance documents, and that also just caters for very specific circumstances and where parties are permitted to not do something or to do something if that occurs. So I've just touched on that. The more interesting item that might apply to players, although this is something that hasn't really been tested yet, is the Doctrine of Frustration. Now, Doctrine of Frustration is a controversial doctrine in employment law, and football players will be employees. So any if an employer tried to, or if a club tried to dismiss based on the Doctrine of Frustration, it may or may not work. This is something that's it's a new area to be dealt with, as the case law I've seen. I mean, the cases are from 1975, 1998, and the most recent one I could find was in 2014. Well, I stand corrected. So this is not a concept that's regularly used in employment law, and although it might be something to consider, I think it'll be quite a difficult doctrine to apply. Just to explain what it is, the Doctrine of Frustration provides that where the performance that because of an event, the performance that parties are required to perform is something radically different to what they initially agreed, then that performance is frustrated, which means the contract can be brought to an end prematurely. Now, obviously, in that case, there's quite a big difference if an event's been cancelled versus delayed. Now, if an event's been cancelled, the Doctrine of Frustration is likely to apply because obviously the performance, you're not performing, so it's radically different from what has previously been envisioned. Whereas where, for instance, an event is delayed, so for instance with the Premiership, although players aren't playing now, they will be playing later, it's quite difficult to apply the doctrine because their performance will still be there, it's just not at this moment.
And Bianca, sorry, can I bring in Paul here? So as a part-time employment judge, how often have you seen over that 20-year period the Doctrine of Frustration used in an employment context?
Very naughty of you, Sean, to ask me about that, but I can tell you from private practice that there's only one occasion, I've been doing this for much longer than I care to think, there has only been one occasion where I've seen it even argued in an employment tribunal, and that was at the time of the IRA bomb in Manchester in 1996. I represented the Royal Exchange Theatre Company, and that theatre was pretty much destroyed as a result of the bomb. So you could hardly think of more appropriate circumstances. Slightly complicated, there were issues there, and it was never actually adjudicated upon. Let's just say the judge made his feelings known within the first half hour of the 3-day case, and we're all in Starbucks by 11:30.
Right, thank you. Sorry, Bianca, I just wanted to sort of get that perspective in. Thank you. Back over to you.
I guess that's the point.
It's very difficult. It's really difficult.
Yeah. So if anyone tried to run that, it would be a very novel argument and you would have an uphill battle. But further, the problem would be it would really only apply if there is actually a cancellation, because I think that the standard common law test for Doctrine of Frustration, which with a radically different performance, wouldn't be met until there's cancellation. Naturally, if events are cancelled and, for instance, dates are very specific. I know John was talking about the contract ending on a specific date, and if that's not extended, then obviously players wouldn't be playing in terms of those contracts. So there might be avenues, but it's something that would need to be carefully assessed and would be a difficult call to make. The next thing would be to look at remedies. Now, as I've said, the force majeure and Mact clauses don't apply in the situation, and frustration, really, it'll just depend on what the parties decide, or whether or not it could be applied in the situation. The last thing that I just wanted to touch on was the point that John raised about FIFA 2 days ago sending through a guidance, and I thought it was maybe from a more junior point of view and from a more naive perspective, I thought it was quite a good guidance. It's showing that they're trying to find a way through all of this. Obviously, I understand practicalities, trying to renegotiate and trying to get, I guess, herding ducks, trying to get everyone together to negotiate something. But I think it's positive that they are trying to make steps to get people to be more pragmatic and to think about the commercial impact. And as we discussed, the fact is, if the league goes down, then it's great that you have a good contract, but if no one's going to pay for you, there's no point in having the good contract. So I thought that was a good takeaway from it. Although I do appreciate from a practical stance, it may not be as useful as I may have thought it was.
I think I can see you having a very long and successful career as a mediator. Yeah, we talked about this last week, and I think I agree with you on this front, that is a very difficult position for FIFA in trying to do something positive. And I think John did acknowledge this when he was speaking, that I don't think anyone's in and everyone's in an unenviable position, because at some point, as not everyone's going to be happy, and often in this sort of difficult time, a lot of people aren't going to be happy because there's not really a good decision to be made. If you see what I mean. Was there before we come on to Q&A? Was there anything else further you were going to add? You've got a bit of time left.
Oh, really? Just the last point is, I mean, I know I've mentioned various concepts, and I mean, they don't really apply to the football player contracts just because the terms aren't actually part of those contracts. But people will see that there's a handout that's been attached, which is called "Give Me Just a Little Bit More Time." This is an article that I wrote with Untitled Qc, which deals with these concepts in more detail and also focuses more, rather than in a purely football player contract aspect, rather looking at them in more depth in a commercial sphere and how that would impact them in the commercial sphere, and what the remedies are and what people should consider.
Okay. Thank you. And I've also attached the FIFA a circular and their guidance on there for those that are interested. Probably everyone's seen it already by now. Right, so we're running slightly behind schedule on this. I'm going to go straight into, let me unmute all of the speakers' microphones, so I think everyone's there. And first up we have Aaron Castro. So we're going to come to you. I'm going to turn your mic on. Hopefully you're ready to ask a question. Aaron, can you hear us?
Yes, I can hear you, Sean.
Right.
Thank you. As you can all tell by my funny accent, I'm an American.
How dare you? How dare you?
John and I have sparred a little bit on a few of these issues in the past couple of weeks on Twitter, because I come from a completely different perspective. I'm an American sports law, I would say, specialist, but I am not an attorney. So let's just put that out there. So attorneys and lawyers.
What's your question then? Hurry up, chop chop.
So this is a bit like long-winded. So
no, we need to be concise. Sorry, just because of time. Sorry, Aaron. I'll
try to keep it brief.
Try and keep it very brief, please, because we've got.
So in the American sporting space, we operate on league years, and everything is conducted via collective bargaining agreement. And one of the things that I guess, obviously your laws are different, but none of the leagues, whether it's rugby, which I work in the States, in the UK, or even in continental Europe, and obviously with the Premier League, have collective bargaining agreements with their players' associations. And in our collective bargaining agreements, we have force majeure clauses that could end up just stopping pay altogether if necessary, because in every one of our sponsor agreements, there are force majeure clauses. Yep. Why aren't there?
Your question?
I guess what is stopping the, reduction in pay, and I would say just canceling the season and this intent to keep going?
Okay, thank you very much, Aaron. Thanks for that. I'm sorry for pressurizing you to be short. It's just because we've got 30 questions waiting to go. I'm going to mute you back again, and then who wants to take that? I can give some input on that, but who? John, yeah, over to you.
Okay, I think there are a couple of competing points. One is there is a genuine desire from a sporting perspective to end this season. It is a way of giving certainty to all the issues that are in play. Who wins various divisions, who goes into various European competition, who gets relegated. That is the fairest way. Then secondly, there is an economic or financial balancing act, isn't there? We've heard about the £750 million that'll have to be paid back to broadcasters if the season isn't finished. And you have to balance that against the cost of extending a season and extended player contracts. I did a quick back of the paper envelope and looked at the so-called 30% reduction in Premier League wages, and that almost exactly tallied with the losses that the Premier League had announced if the season doesn't finish. The idea of losing revenues is a terrible thing, and spending more is also not great. But the idea of having to pay back the money which has already gone towards players' wages, I think would be devastating to quite a number of clubs.
Okay, so next up then, thank you for that, John. Next up then we have Taran Singh, who's basically said, when we're talking about earnings and potential earnings that for football players, when they come from videos of them training, for example, on various platforms, such as YouTube, How does that impact the training criteria as such? Because I think, John, you alluded to this last week, if they're doing all these other activities, if it's perceived that their videos been training. I know for example, in the NBA, they've been doing a lot of videos with players, doing other interviews and stuff like that. I've seen the same in football. How does that impact this if they were to be furloughed?
Well, I might pass this question over to David, because I think he's answered this, which is that furloughing is you are not performing any part of your contract. And if you are performing any part of your contract, and commercial sponsorship, media engagements are part of a standard form player's obligations. If you do any of that, you are almost certainly not going to qualify for the furloughing scheme, and the government won't pay you. But I think that's a point that David made in his presentation earlier.
Yeah, I agree, John. It's exactly.
And do you not think there's going to be some flexibility with this, given the current situation? Do you think, or they think it's, typically it's going to be quite a hard line approach?
If I can butt in, I think historically, if the player, as many of them have done, have already done the photo shoot, taken part in the relevant event, and it's in the can and it's being used by the club, that's one thing. I don't think that would jeopardize a furlough arrangement. If, however, they go out and undertake an activity right now, that would be in contravention of the furlough arrangement. I actually think it's an academic question, because the level of player who would be involved in that level of activity is going to be earning so much that he wouldn't be suitable for the furlough scheme anyway.
Yeah, thank you. We've got a question, point. Sorry, David, did you have anything you want to add on that?
No, that's fine.
No. James Hill's made the point, I don't think there's a question here, but says, is the government's JRS scheme, is the government JRS guidance on training not aimed at occasional ad hoc training, which is clearly distinct from regular requiring a player to comply with the club issue training plan on a daily basis, which forms an integral part of their job, play and match? I think you've now answered that.
I think there's going to be a tension between that and the safety guidance, which is what the police are enforcing, which the Tottenham example is a very good example of a reaction on the ground by the police to public safety matters and observing people not observing social distancing, as opposed to not complying with furlough arrangements.
Right, okay. So David, you were going to say something.
No, I mean, there's no easy answer to this. I do think that the training aspect for players, it's as I said, it's intrinsic to their job. They have to do it. But with regards to formal instructions from their club, I think my view is that I think it would take them out of the furlough agreement.
Okay then. And so next up, we have a comment from Bilal Mehrzad, sports insurance lawyer. If a player is furloughed and still undertake club direct training, they could fall foul of not being able to benefit from the club's this is interesting, employer's liability, personal accident insurance, should they suffer any injury. John's shaking. John.
No, I think it's really important to emphasize that the furloughing scheme is, if you like, I think I labeled this last week as a form of state aid to businesses to prevent them going under and increasing the number of people on unemployment benefits. It is not an amendment to employment obligations. All it is that employees, i.e. players or any furloughed staff, don't have to turn up to work. All the club's obligations, inclusive of insurance and still apply. So if for example, and let's make that clear, that insurance is probably only going to cover, for health and safety aspects, injuries at work. So if that furloughed individual falls downstairs at home, then you'd have to look at the policy, but it's probable that wouldn't be deemed to be an injury at work and be covered by their insurance anyway. I don't want to go much further because you have to look at the policy. idea
Okay.
that furloughing voids coverage is not right.
Okay, and then this is one for Paul. This is from Jan Neil. It says, on what Paul said, in the ordinary course of business, financial meltdowns can be seen to be partially the fault of a club, or at least could have been handled better. The COVID-19 situation seems surely remarkable, and it's surely hard to place any blame or fault on the part of the club. Would this play into the panel's consideration of special circumstances?
I don't think it's really an examination of fault. I think the tribunal, you're talking here about a collective redundancy situation, a statutory collective redundancy situation. The tribunal looks to the employer to demonstrate that it has done what it can in the circumstances. So it can't meet in full the full checklist of obligations, but the tribunal will expect it to go as far as it can. So for example, on time scale, if you can't do 45 days, you do 35 days or something like that. It's doing the best that you can to really say to the tribunal, well, what else could we have done in this situation?
Okay, thank you. Then we have a question from Nicholas Gomez. He says, in a realistic but hypothetical situation where a country such as Spain is still on prolonged lockdown but others are not, do you foresee a situation where players in Spain will seek to get out of their contracts through frustration or under the right to work argument? John, I think you touched on this a little bit, that their skill require them to maintain their skill level, basically to retain their skill base, that they need to actually have competitive matches.
Yeah, sorry, Sean, hopefully you can hear me.
Yeah, we can hear you. Yeah.
The question cut out slightly. I think I heard the back end of it, which is in relation to players are not required to turn up, but have to maintain a degree of fitness. That's actually a term of all football contracts in this jurisdiction as well. You have to maintain a level of fitness at all times, which is why this idea of training even by yourself is quite controversial, because you are in effect complying with a contractual obligation for the benefit of your club. There's a second point, which is about sort of health and safety, which I might leave to David, because we discussed this in advance, about this idea of a season up and running straight away and how players can actually be in a safe position to do that.
Okay.
Yeah. Yeah, sorry, do you want me to add on to that, John?
Yeah, go for it.
Yeah, it's, as we spoke about, John, we don't know when the season's going to resume, if at all. But in any event, well, in the normal course of events, players, given the prolonged break they're having here, 3, possibly 4 months, players, they've got a month, 6 weeks to get themselves back into shape with their club in an organised manner. Here, we could possibly have an announcement that the league season will resume on X date, and they're straight back into it. And as I spoke about with John, they're not given the opportunity to bed themselves into the season. In this case, they're finishing seasons, and the business side of it, the promotion, it's relegation, it's going for championships, Europa League, all of that type of thing. So they're going straight into it. So clubs need to be aware of that too, and their duty of care towards the player. They can't just say, right, we're going to play, get you back in and play straight away. There's real issues involved in that too.
Yeah, I think they're very. Yeah, I think you're right. Very live issues, right? Ben. Sorry, Bianca. Yeah, go for it.
Just one point, and I may have misunderstood the question. I thought the person was asking about Spanish law and the Doctrine of Frustration.
So he was basically asking, could you foresee a situation where players, I guess, around the world, but particularly within Europe, would essentially argue that they could use the frustration to get out of their contract because they say that it's a requirement that they, as part of their work, that they have to be match fit.
It just needs to be, we just need to be quite careful there, because the Doctrine of Frustration is an English law principle. So, well, common law countries will have some kind of doctrine like that, but in any kind of civil law country, you'll have to look specifically at what principles they have that'll deal with that. I'm sure there'll be something, but it won't necessarily be the Doctrine of Frustration.
Yeah, and there's been on that. There's a Sports Law Institute which Tony Rocca's been doing with a bunch of other Spanish lawyers like Emerick Ripoll. So I would advise you to go onto YouTube. You can find that. And I think one of the deals, Crespo Perez as well, has covered a lot of the Spanish. I don't speak Spanish. I haven't tuned in. So, but I think if you do speak Spanish, then it would definitely be worth your while checking that out for sure. Right, Ben Cineros, we're coming over to you. I haven't checked whether I'm saying your name right, so sorry if I'm not, so correct me. I'm unmuting you now.
My question, funny enough, actually relates to the question about frustration. And sort of in the same way that we were talking about all the sort of ways that clubs would have to ensure that their players were genuinely furloughed, they were genuinely not working, would that not also potentially preclude an argument about frustration? Because just because players can't play matches, that doesn't necessarily mean they can't perform the obligations under the employment contract, given, like we said, that their obligations are potentially so broad, you know, with regard to media, training, what do you think about that?
Anyone want to take that? So I think what you're saying is, I think we've got a related point. Thanks, Ben, but to correct me if I'm wrong, we've got a related point, I think, from this, from Craig Harris, who said, where do players, other employed staff stand giving interviews, etc., to journos, even if it's not part of the club's contractual obligations, revenue purposes? Essentially, personal decisions to be interviewed for their own PR. Many are conducted that jumps between the two. They approach their club, etc. Helping generate, might this raise issues around their furloughing? But I think we covered this point earlier, really, about the type of player that's going to be involved. But I guess it's still very relevant.
So my question was more to do with frustration and furloughing. Just, you know, the way that players could potentially be obliged to do many things other than simply playing matches. If the season is cancelled and the matches can't be played, that wouldn't necessarily mean the contract's frustrated, right? I mean, this is sort of open to anyone. It wasn't directed at anyone particular. Sorry.
Thanks,
well, I
Ben.
mean,
appreciate
for there to be frustration, there has to be, you need to meet the test, which is basically the performance that's now being performed because of the supervening event is radically different to the performance the parties had envisaged. So, I mean, I guess it really depends on the terms of the contract, and the terms of the contract will circumscribe how the doctrine of frustration would be applied. But obviously, if 90% of the contract can be performed, 10% can't, you would have to see how that would fit in. I guess and that might also be a problem as to why this isn't something that normally gets brought up in employment tribunals, is because to dismiss someone on that, you would need to show that none of their contract could be performed.
Right.
But I mean, it's something that's very novel and hasn't been in the courts recently.
Can I jump in, if that's all right?
Yes, absolutely.
I think this is a really interesting debate, because the central purpose of a player contract, it goes without saying, is that the player plays. And let's say that contract is going to come to an automatic end on the 30th of June, and the player cannot play due to events out of the control of the parties between now and the 30th of June. For players whose contracts are going to continue for a few years, this doesn't affect them, because they can play in the future. But between now and the 30th of June, they can't play. That's the essential purpose of the agreement. Yes, they can give interviews to the media. Does that mean that the contract is radically different than that envisaged between the parties? I mean, it's open to argument, but the one hypothetical, or that I'm thinking of it by way of comparison, imagine a player that was injured now and couldn't play until the 30th of June anyway, but could carry out media interviews. You would never argue successfully that that player's contract was frustrated in those circumstances. And so I have to say, whilst it's open for discussion, I am really struggling with the idea of frustration in these circumstances for the reasons Bianca set out. But it's a really good question, because a top player is not just there simply to play, even if that's the key aspect.
And I guess this will be, just to take the one point, I mean, I didn't go through it in my bit of the web of the discussion, but the one point that I just want to highlight is from the case law. I can't think of the full citation now, but it's the Canary Wharf case where they were dealing with the rental of the building. The court there looked at frustration in detail and specifically said whether contract is frustrated depends on the consideration of the nature of the bargain of the parties when considered in light of the supervening event, and only if the supervening event renders the performance of the bargain radically different when compared to the consideration in play at the conclusion of the contract will the contract be frustrated. So I guess that ties into your point, John, about what was the purpose of the contract. The purpose wasn't for him to give interviews, the purpose was to play the game.
And I guess this is where I think we're gonna do another webinar, hopefully at some point in the next few weeks, on tax issues, because I think this raises some very interesting tax issues, particularly if you've just paid 25% into an image rights company. But again, probably anyway, raises some very interesting issues, I think, later down the line. I'm determined, because we failed last time, to get through all the questions. So Chris Clark, I can see you put your hand up. I'll come to you in a minute. Demetrius Diminaou, in relation do not have the same problem, right, in order to avoid the problem in the future, do you believe it's a good idea to include a clause in the contract in a situation of circumstances where the players have to reduce wages? I would imagine that given this situation, that this will be part of a discussion going forward in terms of what happens in such a situation, given that they think these type of viruses is going to become more commonplace anyway.
Definitely
if I could
questions
take that,
David.
Yeah, there is a mechanism for.
Who wants to take this? Sorry, David or Paul?
There's a mechanism. I'll go first. There's a mechanism for the standardization of contractual terms in the Premier League. There's a different one for Championship below, all the way down to National League. Yes, we can come up with some kind of formula that could cater for this type of situation. What it will be impossible to legislate for will be the precise criteria against which it is judged that the relevant circumstances have arisen. You're never going to get away from that. You will never be able to have a clause that's going to be enforceable that caters for all possible circumstances.
Sorry, David, do you want to add something? Sorry about that.
Yeah, no, I agree with Paul, but I think as well, you will have one mighty argument on your hands with regards to the players and their agents to get any form of reduction in their wages. I know they've been trying to reach some agreement with regards to deferring Premier League wages, but given the power of agent stroke intermediaries, I think that'll be quite an argument to get that in contracts in any event.
Do you not think, though, that the mechanism to deal with this would be better placed? So, like you have an arbitration agreement, you have a mechanism to say in such a scenario why the clubs will have to disclose X, accounts, figures, and all this other stuff that was presented by Alexandra last week from FIFPro, which was saying that on the same point globally, as long as players know what's really going on financially, then we're more happier to agree to reduce wages. So surely there'll just be a mechanism within the contract. I think, John, you were mentioning at some point as well, saying that there's, if I'm correct, that there's a policy for reducing wages amongst if relegation occurs anyway. So that type of clause already exists. I'm not sure if John can hear us. I think he might be having connection troubles.
John?
John,
yeah,
can you hear us?
I can hear you. Hopefully you can still hear me. Sorry for the brief interlude. I just want to say that the parties to put into the schedule whatever terms they like, and it's fairly standard for clubs to agree with players that in the event of certain events that will lower their income, for example relegation, then players' wages will be cut, and it's the same thing with managers, and that is to reflect that income is going to go down when you drop down a division. So if you want, you could simply contract in that in the event of the club income dropping below certain levels. I mean, it's quite difficult to draft, but in theory you could put that in. Variation clauses are much more difficult, as Paul knows. There's kind of implied terms about the extent to which you can use them.
Okay, brilliant. Okay, we're going to come to Chris Clark, and then we've got 2 more questions to go, and then we're going to wrap up, just because I'm sure It's a bank holiday weekend here anyway. Not the effects. It doesn't. Who would know, right? So it feels like every day feels the same at the moment. But Chris Clark, I'm going to unmute you and let's have your question, please.
Thank you, Sean. I actually had 2 questions. I'll be very quick, and if it's possible to go through 2, let me know.
Go for it.
David,
go for it. It's a pleasure to hear your voice, Chris.
Thank you. David, you might be able to help out. I understand in Scotland there's actually a different provision that the collectively agreed player contract there makes it much easier and actually allows for deferrals or even cuts to the player contract, which isn't in place in the Premier League, FA, Football League standard contract over here. I don't know if there's
understand. Yes, Chris. Yes.
I don't know if there's any info you can, just a bit of background or differentiation as to why and how that works, and could you foresee that coming into the English game?
So let's do that. And you've got another question as well. Sorry, Chris.
Sorry.
Have you got another question as well, Chris?
Yeah, sorry, the second one.
Yeah, okay, so let's do your first one first then, and then we'll come back to you. So I'll leave your mic on. But David, do you want to take that?
Yeah. Chris, I don't know how it actually works. I have heard of it. When I played, unfortunately, didn't have that around. But I go back to the previous question. I think we're in uncharted waters here with this, with the whole COVID thing, and trying to incorporate something like that going forward in a contract. We can foresee relegation in a player's contract. You're fine, but something like this, a one-off, I don't know how we can incorporate into a contract, and B, whether, as I said, mentioned with agents, intermediaries, whether they would be acceptable to that anyway. But getting back to your question, Chris, in terms of Scotland, I don't know. I've heard of it, but I don't know the mechanics of it.
We can find out about that, and we'll find out about that and come back to you, Chris, on that point. And then you had a second question.
The transfer market, the transfer window. At some point, there will be an end of the 2019-20 season. Yeah. There will be a break, a transfer window that will be adjusted across the world and set by each country, and there will be a start of a new season. The transfer window is based upon, governed by, requires contractual stability. But this is testing contractual stability at best right now.
So what's the question?
Just to understand what the panel's thoughts are, how this will actually impact the transfer window, values of players, and where there may even be breaches of contracts, how that could impact the transfer window in this particular summer.
So to summarise, a movable transfer window at this moment in time, and given FIFA's guidelines on, we hope we extend the contracts and hope everyone reaches this agreement, how is that going to affect the valuation and future contracts? Is that correct?
Yeah.
Brilliant. Thanks, Chris. I'm going to unmute you now. Thanks. Who wants to take that? Anyone?
I'm very happy to kick off as always. Let me just say 2 things in response. One is very indirectly responding to it, and the second one I hope will respond to it. First of all, a really excellent point that was made in last week's webinar is that in order to have a coherent and workable new delayed transfer window, you have to have seasons across the globe, certainly in terms of the major leagues across the globe, their end and their ending coincides at the same time, and therefore their new seasons start up at the same time. Because otherwise you have this absolutely unworkable situation where transfer windows are opening or closing before or after seasons are ended, and that will be the polar opposite to contractual stability. So that's point 1, which is a sort of indirect answer. Second point, what do I think the effect is going to be on transfer values? That ultimately is a pure economic point. And I've said this, forget about football, this is going to be across sectors across the globe, that you are going to have a decrease in the value of these transfers because there is less money in the game and there is less money to use in the short term. I also don't think, and I've read various articles about this, that this is going to be a short-term reaction. I can see transfer values being undermined, save in the most acute of cases, for potentially the next few years for this reason. That's
Well,
my thought.
and just to contribute onto a wider, no doubt we'll do something on this. The football valuation market has been a very bullish market. If we're talking about as you know, from an investor's perspective, it's been very bullish, and particularly around data, purchasing of data, betting opportunities. And just before all this hit, particularly in the UK, there was obviously this change in attitude towards betting. So there's already this sort of volatility, and there's other things going on in the media rights space. And so all of that is going to trickle down. I think, you know, from a tech, if you're looking at from a business perspective, lots of these businesses are always running on the fact that in the future, hence why we have financial regulations, that they're going to make loads of money. It's always very speculative, right? And then that now is some of those models are going to be tested very thoroughly. And one would think that if there is good governance comes to the floor and making sure that that they can run effectively and smooth for the long-term success of football, they'll have to address some of these points. But again, it's all very speculative. Guys, I don't know if you want to add anything. We've got, and then we're going to come on to a really rapid fire question. There's a clarification point and then rapid fire questions. Okay, I'm just going to move on then. So just a quick one, again, just a clarification. In terms of, can furloughed players at the request of the club engage in supporters communities via social media with good news stories, health advice, community support, which I think is slightly different than the commercial aspect, but that wider sort of community, if the club says, look, hey guys, can you get involved? Does that jeopardize it as well?
I think, is it going to generate revenue for the club directly or indirectly?
Indirectly, I imagine it will, but if not goodwill.
Yeah, if so, then it's arguable. Yeah.
Arguable.
Yeah.
Okay. Thank you. Okay. Jonathan Booker, as I said, just for clarification, the FIFA guidance is adopted by the likes of the FA in terms of extending the season or adjusting the transfer window. What are the implication dates specified in representation agreements? There we go. That's a great question. Between the parties of clubs. Those dates which imply where to correlate with dates in the original football calendar will possibly be legally recognised on the revised calendar, and those which are not implied to correlate possibly will not. Good question, Jonathan. Who wants to take that?
Well, it depends on, as all of these things, it depends on what the individual contract says.
Yeah.
So if the contract specifies a date, then that is at least the starting point, possibly the end point for the analysis. If it has a more flexible definition and it is clear that the party's intention was that the contract would come to an end at the end of the relevant season, then a different conclusion would follow from that.
So if they've been too specific with their wording, essentially at this moment in time, if they've, say, for example, the calendar, and they've chosen a calendar date as opposed to, and not used the word season, that could potentially be problematic.
Yes, I mean, sometimes you see a playing contract or a managerial contract that is referable to, because it's, for example, the typical contract would be 3 years in length, whether it's a player or a manager, and it will say the end point is the last date upon which the first team is engaged in the blah, blah, blah competition. So it'll be in the Premier League competition for that year, or if it's a national manager, quite often it'll be the date of the last competitive match played by the national team in the 2016 Euros, the 2018 World Cup, etc., etc. And that's a much safer definition for the employer than a fixed date contract.
And so if you're an agent at this moment in time, and I know there's a bunch listening or watching the recording, which will be available on YouTube and on LawInSport as well, either later today or at some point tomorrow, would you be advising them to be trying to get, if they're now listening to this going, oh God, maybe I should do something, that they should probably enter some negotiation to amend the contract?
Well, if the employer, the club, whatever organisation it is coming to the player seeking dispensation from what's actually in the contract, that's the ideal opportunity to say, well, the quid pro quo for this is that you must now consider our proposal as to the length of the contract, because we're reacting to the emergency on your behalf and we require you to reciprocate.
Great. Okay, and then we've got a question from Phil Draper, who's asked, how does it compare to, say, if you've got an IT manager who's with this issue around training and furloughing, if you've got an IT manager who's at home, whose fundamental job is to stay abreast of the latest developments with IT, for example, how does that differ from a football player? I think that's what he said. How do you differentiate between an IT manager completing online training on a platform provided by his employer and a player completing his fitness regime provided by his club? In practical terms,
yeah, I think with the IT, it's over and above what he is doing. He's further education of a sort. With a football player, training is actually part and parcel of the job. They have to do it every single day, full-time players anyway. So as I've said, it's intrinsic to the job. It's not an add-on. It's not in addition. It's part of the work that they undertake every single day. This training, as I've mentioned, is something additional. That's my take on it.
Okay, that makes sense.
Yeah, I think that's right, because there's the specific clause within a contract that you will attend training, stroke keep yourself fit, and in return for that clause you get paid. And so the idea that you can carry on that training and say that you're not performing your contract is going to be really difficult for players. An IT consultant, just in broad terms, who's deciding off his own bat whilst at home to attend some online training courses simply to further develop their own skills, that's not directly referable back to their IT consultancy agreement, nor is it something in relation to which they are being paid. And I think that's the key fundamental breakdown.
Okay. So we got, I think, I'll tell you what I'll do. Cambyse has asked a very great question. Cambyse Heron has asked a really good question, but I think just because of time, we've run over anyway.
Go on, ask it. We know him very well. Yeah.
Okay. Question: in relation to FIFA's recommendations on the extension of player contracts and transfer windows being rescheduled, if a player who contracts comes to a term on 30th of June, but whose club does not wish to extend the contract, if the transfer window is moved and the player cannot join a new club, what happens? Is this essentially a restriction of trade of the player? Does FIFPro, the PFA, have a form of de facto duty of care? Who wants to take that?
John.
You look like you. I was worried there. You're holding your breath for so long.
I mean, I'm only going to say this. I'm only going to say this because I kind of tweeted out about this before, saying that the idea that at this late stage, with players having already entered into other agreements which are due to start on the 1st of July, that a regulator can effectively, by almost sort of by unilateral decree, change the transfer window to deprive them of an economic benefit, I suspect is challengeable in terms of the effect that it has on that player in terms of their ability to carry out their trade. I will just mention this, of course, you can sign a new contract to start on the 1st of July, but you may not actually be starting training with that club until the end of July. So a lot of this depends on the exact dates of when seasons are extended to and when new seasons begin. Because if you would have been lying on the beach anyway, but just being paid, that may not be a restraint of trade. But I do think there are legitimate restraint of trade arguments to be made about players who now cannot join clubs and otherwise would be left effectively without a club. I hadn't thought it through in terms of jurisdiction. It's probably a Swiss law question anyway, because FIFA are in Switzerland. So I don't want to go too far on that.
Okay. Well, thank you for everyone who's tuned in. Well, first of all, and I did this before, I don't know, I have to get a soundtrack, right, to do an applause, because one person, or I have to get the kids in and try and get them to do a group applause. Thank you so much to the speakers for doing this so quickly. We literally got this together in, I think, record time. we only announced it yesterday, but it's such an important issue. We felt before the bank holiday weekend, wanted to help provide some clarity, because no doubt there's going to be ongoing discussion. So from all of you, wherever you are, whatever stakeholder group you're representing, or individual club or agency, hopefully you found that useful. Thank you so much to the speakers for your time in prepping with this, just into the tech as everyone else is. Remember, if you want to access this, it will be available on our YouTube channel. We're doing a whole bunch of these pretty much as and when we feel that there's a need to provide some clarity. They can all be free to access on this stuff. We've also got our ongoing webinar series, which we started at the beginning of the year anyway, which is free for our Plus members, a small fee for non-Plus members, which is on broader sports or issues. That will still continue. And also, if you want to keep up to date basically with all the legal issues that are taking place around the world in sport, you need to go to lawinsport.com. Of course, I would say that. Other than that, if you enjoyed this, if you value what the speaker said, if you've got any further questions, go to our forum that's on the website. So go to the More tab, click the forum. You can ask questions. There's already been some great discussions in there. There'll no doubt be more on that. And yeah, please tell people that you enjoyed it. We really appreciate you for tuning in. Hopefully it was helpful. You can always ping us a question if you do, and I'll try and forward it onto the speakers or put it into the forum. So there'll be some assistance there. And good luck for all of you trying to tackle and deal with this issue. Good luck with that. For the rest of you, I hope you're staying well and safe. And any thoughts go out to any of those who are not well, or your family or relatives are not well at this moment in time. And we wish them all the best wherever they are in the world. And other than that, have a great bank holiday weekend. Thanks so much. Thanks everyone.
Thanks. Bye.
Thanks, cheers.
Ciao.
Thank you. Thanks, everyone.
Bye.
Bye.
Well done all.